Sir, I have a question for you.
Yes, sir.
I just wanted to know, are the judges always correct in giving their judgment?
So, judges are always correct means judges are also human beings. So, it is not necessary that they have to be always correct or always wrong, because the constitution has gifted you plenty of remedies. Okay, if the magistrate errs in giving you a judgment, you can go to the district level judge. Then after that, you can go to the high court. Then again to the Supreme Court. Supreme Court again gives you 3 more options. If SLP is dismissed, review petition is there, curative is there. So many options are there. But the problem is always the clients and the advocates think that the judges are always wrong. This is the opinion, everybody, because judges are driven by the subject, the actual law. Law is very complicated. It is not based on only facts. The law has also the interpretation is something like the facts has to be looked upon along with the law, the relevant sections, and what are the binding precedents, what are the judgments of the High Court in this particular this type of case, what are the Supreme Court rulings in this particular case. In that way, the whole presentation involves lot of work from an advocate presenting to the judge, stating that these are the facts, but these are the legal grounds, these are the law points, these are the questions of law, substantial questions of law, and then these are the judgments, and then the honorable judges will come to a conclusion. Based upon their interpretation, they'll give the judgment. So
we cannot say that a particular judge is 100% correct. That maybe that is the reason you have so many higher courts for going for the appeals.
See, that is a very much debatable question. I appreciate you for that. It's not only you who have asked this question, because a person has committed a serious crime. Let us say he has been convicted by a court of sessions. Then the High Court has also convicted him. Then Supreme Court also has convicted him, in the SLP has dismissed. The review also got dismissed. But again he petitions the Supreme Court for a 3-judge bench hearing in the form of curative. Then the curative petition, the Honorable Apex Court, what it will do, it will turn around the Supreme Court ruling also. That means the division bench of the Supreme Court is wrong, the division bench of the High Court is wrong, the Honorable Sessions Court is wrong. So that is not the point. See, whether somebody is wrong or not has to be decided by the Supreme Court only. Whether that is called the appellate jurisdiction. Only the Honorable Supreme Court enjoys the appellate jurisdiction pertaining to the trial courts as well as the High Court. And High Court enjoys the appellate jurisdiction of the sessions as well as the magisterial courts. So once any erroneous or perverse judgment is passed by any of the judges in the country, always the Supreme Court is in forefront to set aside such kind of a perverse judgment. You should say it's a perverse judgment means judge has not applied his application. There is no application of mind. In mechanical manner he has passed it. Or else there is something called judicial propriety and judicial decorum. Those are the rules, very stringent rules laid down even for the judges to take decisions. It is complete science. You're thinking giving judgment is a very small thing any advocate can do. No advocate can do that. Other day in the Telangana High Court also, one of the honorable judges have asked a question to one senior counsel, can you adjudicate this matter? He said, no, my lord. So that is the answer, because a judge has to be neutral and he has to apply lot of things. Otherwise in the judgment they have to write why these judgments are not applicable, why this question of law is not applicable to these facts and circumstances. Or what are the facts? Lot of people get again carried away by High Courts and Supreme Courts, thinking that the High Court has meted out gross miscarriage of justice to us, and the judge has got colluded with other side advocates and judges and all these kind of wrong accusations they make. But that is completely wrong. The High Courts and the Supreme Courts are not fact-finding courts. They are only on question of law. Let me give you an example. There might be an XYZ person, he's an hardcore murderer. There can be a CCTV footage also. Everything is great. Let's say all the depositions, everything has been done in the courts of session. Okay, the court of session has confirmed, given him a life sentence or death sentence. The High Court has to confirm, and they have confirmed it. Now the Supreme Court examines. Okay, whatever the facts, that is relevant facts as well as the facts in question, all these facts have to be established at the time of trial. So all those things will be only in paper. The Supreme Court will not look at the face of the murderer and decide whether he is innocent or not. Everything what the witnesses have said, whatever, whether they have stood the cross-examination or not, all those things will be taken into consideration to establish a fact or a relevant fact. Once these facts are there, then whatever there is a question of law, let us say the High Court has also confirmed and given its verdict confirming the Sessions Court's decision, alright, the judgment. Then there are errors in the High Court and also the Sessions Court's judgments. Only the fight in the Supreme Court is only on the errors on the judgment, neither on the facts nor on any other things. That is called question of law. So only on the question of law, there are several cases. Even in the recent times, there are people who have killed small little girl, raped her and murdered her. Gang rapes, mass murders, but still Supreme Court has not found out the evidence and said like the whole case is botched up by the prosecution. There is, in spite of concurrent findings and consecutive findings by the High Court and the Courts of Session, still they have acquitted the accused.
So it's always you have that choice, to approach the upper court, then so that your case might be reversed. So I think because
yes, that is how the constitution has been written. This is not Taliban, okay, where on the spot you will be delivered justice, whether that is correct or not, they will shoot on the point blank.
My question was like, it's not about Taliban or something. My
so
question
many remedies
was very
are there in
simple.
constitution.
My question was very simple because I was feeling whatever the judgment the judge will be giving will be the final. So, but still, when he's correct, why should we approach the upper court? That was my question.
You will not approach. If you are winning, then the other party will not leave you. He will approach.
So you have that.
He will win next time. Again, you will approach much higher court, and next time you will win.
Then I think we should have a system where
See, that's what
you should have so many courts.
Yes, already there are so many courts. There are 4 levels of courts in the country: trial courts, courts of session, high courts, and the Supreme Court. And that's why our global and the Indian, the guru and mentor, Ram Jethmalani, late Ram Jethmalani sir, always says like, if you want to prove somebody guilty, then you have to prove it in the highest court of law, that is the Supreme Court. And Supreme Court acquits you, then the person is innocent. Okay. Even if High Court has convicted you, you cannot say anything to him.
Okay, sir.
Because there is always suspension of sentence, if of suspension of sentence by trial court or sessions court or even High Court or the Supreme Court level. And that is not the last. Even if the Supreme Court convicts a person, then also the person can move the mercy petition before the Honorable President and beg to get exonerated, or else or some kind of relief, okay, or else he can also petition the state once he started reform. See, the criminal jurisprudence of Indian criminal jurisprudence is all about reformation. It always gives a chance to a murderer or rapist also. Okay, even a person is a hardcore criminal. He might be a dacoit who has got 30-40 murder cases against him. He is facing life conviction. But if he works hard in the jail and if he feels the remorse, he regrets that whatever his actions are, then always he has got one more chance. He will get a remission from the state. Okay. There are a lot of prisoners. That is the policy. Even the Supreme Court asks the state governments, the Supreme Court always puts the state governments on notice and say, why are you not giving remission? Because that is called incarceration. If somebody is in jail, incarcerated for decades together, he will go mad. A person cannot be, according to me, a person cannot be in jail for more than a week. If he stays in a jail for a week, at least he will feel that he is stayed in for years together.
Okay, sir.
So what about the person who has stayed for years together and decades together? He's just living like a mechanical robo. Just think of him also. Every second, every minute he is dying. He also needs justice end of the day.
Yeah.
He has remorse, he has regret, and he is working, and he has proved his this thing. He should be brought back into the society and given a chance. Other countries will not give a chance, but Indian government and Indian country's policy, the Constitution of India gives a chance.
Okay, sir. Okay. I got the point now. Thank you very much, sir.
Thank you, sir.
Thank you.